in another state. Now, I was talking about states because that's the definition of an international armed conflict. Okay, so an international conflict is when there is exchange of hostilities between states, right, India, Pakistan, or when there is the use of armed force by states. Okay. There is a problem, however, as to whether, in order to have an armed conflict, because if you have an armed conflict, then the humanitarian law applies, the laws of war apply, you can derogate from human rights, and humanitarian law, of course, it can accept some human rights, but usually it's based on, there's a compromise between humanitarian considerations and military necessity, but humanitarian law is something that should be very clear. It's not to stop state fighting. Humanitarian law is about facilitating states to achieve their objectives with the less, if possible, humanitarian casualties or human casualties. Okay, so humanitarian law is not human rights law. It's not that you shouldn't use force. It's that how to use force to achieve your aims, but with the less possible casualties, so humanitarian consequences. Okay. So the question then is, if you need a certain threshold, right, to reach an armed conflict, and then for humanitarian law to apply. Okay. For example, you have Kashmir, and then you have the borders between Pakistan and India. Okay, you have I don't know, a drunk Pakistani, I don't know if they're drunk, but anyway, perhaps they can smoke something. And then they shoot an Indian soldier, right? And then the Indian soldier shoots back. Okay, there's exchange of fire. Is that an armed conflict between India and Pakistan? Or, of course, if you have the invasion of India to Pakistan or Pakistan to India, yes, you can say it's an armed conflict. If you take the 2003 war in Iraq, yes, okay. But if you have an incident like that, 2 shots or 3 shots or whatever, do you have an armed conflict? This causes a lot of controversies because according to the Red Cross, any exchange of fire means that you have an armed conflict. And the reason being that the existence of the armed conflict is a factual situation, and they try to simplify. Okay, so if you have an exchange of fire, it's an armed conflict. However, the consequences, okay, states may say it's not an armed conflict because if it is an armed conflict, it's also a serious stuff. Okay, but some states may be very trigger happy. Okay, so there is the other view, which I think is the better view, but that view, okay, it can be supported by the US, UK, etc., which says that there needs to be a certain threshold of violence in order to say that you have an armed conflict. So it's not any exchange of fire, but a threshold. You need to reach a certain threshold. Now, the equation for that is, where is the threshold? Okay, so it helps to the extent that humanitarian law does not apply immediately and does not change all the situation or the legal situation that applies within a state or within states. But if you go towards a threshold, different states may have different thresholds, right? So if you are the state of, I don't know, Nepal, and you're in war with China, well, China has a different threshold. China can kind of sustain more casualties than Nepal, for example, right? So that causes problems, but at least does not change immediately the legal status. And of course, states can deny that there is an armed conflict. The Red Cross usually is the one that informs the state, saying that you have now an armed conflict. But that can create problems. And that can create problems for the application of the law. Okay. Sorry. Yeah.
So earlier you mentioned that an armed conflict is it's something that is a factual existence.
Yes.
It's a question of
Yeah.
fact. So then how does it matter if a state denies it or not?
Yes. What I'm saying that it doesn't matter if the state denies, but if you go to a threshold, then at what stage, if the state always denies that there's an armed conflict, and you have a threshold, then it makes things more difficult. Okay, it's a factual situation, yeah, but states always deny that there's an armed conflict. The Red Cross will come and say there is an armed conflict. Okay, states, may still deny. Usually they accept what the Red Cross says. But what I wanted to say that if you have the minimum thing, any exchange of fire is easier, right? If you go for the threshold and states deny it, then where is the threshold? It can be anywhere, okay? But it's a factual situation, and the Red Cross treats as a factual situation. So if you cannot say when the armed conflict starts, okay, then it can cause problems as to what law applies and whether war crimes are committed. Okay, I can give you another example, 9/11. Okay, you had 9/11 in, what was October of 2001, you had the US action against Afghanistan, right? When did the war start? When did the war start? 9/11 or in October? Okay. So it was 9/11 the first shot, and then in October was, when the US responded, if you like. Okay. If 9/11 was the first shot, then the humanitarian law would have applied from 9/11. So all the people will be prisoners of war. Okay. Now, if the war started in October 2001, then humanitarian law applied from that time. Okay. So when it starts, when you have it, it's not always clear, and that affects the application of the law. The second issue is, of course, the definition of kind of international and non-international, right? So international is between states, but you can add more kind of wars as being international. So nowadays, states do not go to war, but they use proxies. Okay? They use other people to fight for them. They use, armed groups, etc., to fight for them. So is that an international war if you use a proxy?
It can be with the condition that proxies should then have certain semblances of an organized force, say a chain of command and internal disciplinary mechanisms.
Yes, but they need also to be linked to a state, because then it becomes international. So it's how you link it with the state, right? Is it an organ, a de facto organ? Is it under direction, under the instructions, under the control of the state, or what's control? by the state. And for armed conflict, the Tadic case, the ICTY, applies the overall control criteria, which is a looser criteria. It's the general influence you have on the armed group. It's not the effective control, which is the input you have on the act. So there's a looser criterion. But again, there are controversies, as to how to characterize proxy wars. Another war that is characterized as international is the wars of self-determination. Okay, if you fight for self-determination, that's an international war. What about UN forces? I mean, you are aware that UN, there are peacekeeping operations, and I'm pretty sure you are aware of the sexual exploitation mainly. I mean, there's a lot of other stuff, but there's sexual exploitation by UN forces that they use girls, boys, whatever, for sex, etc. Or just give them a bit of not money, some food, etc. in Africa or wherever. And of course, they often fight, they can commit war crimes, but the question is, it is accepted that humanitarian law can apply, but the question is, is it an international conflict or they're involved in a non-international? So if they are within the state, okay, and they are fighting, say, on behalf of the government, other forces, is it an international, non-international, etc.? So this can cause problems because if you don't know exactly what law you're going to apply, it's very difficult to say, what would be the whether you commit a war crime. It may be or may not be depending on the law you apply. I think the better view for the UN is to say that the law of the international conflict that applies to the UN because it has more protection. But if the UN works on behalf of the government and fights forces in a non-international conflict, then perhaps you could say that that is the law of non-international conflict that applies. But again, as you see, there are certain problems. Now, non-international armed conflict. What is a non-international armed conflict?
One taking place within a state, not falling out to other states.
Yes. So it's the one that takes place within a state and groups within the state. Now, the problem with non-international conflict is again about the criteria for the existence of non-international conflict. The provisions that we have, they don't really kind of define, the criteria. You have common Article 3 to the Geneva Convention, and then is the definition of Additional Protocol 2 of what's a non-international conflict. Now, the problems with that is that they have the Common Article 3 does not say anything. The Article 1 of the Additional Protocol 2 defines, but it is very strict definition. So for the questions for non-international conflict is the issue of the organization, the groups should have certain organization and there should be a certain intensity in hostilities. The threshold is something which is above riots or disturbances. Okay.
So according to me, the second criteria, the groups must be organized in the first.
And the other is the intensity of the hostilities. Okay. So a non-international conflict exists if there are hostilities above or exchange of fire above riots and internal disturbances. Now, how far above? You know, it's an interesting question. Northern Ireland, in fact, it was a non-international conflict. You have the intervention of, if the police cannot control it, and you send the troops to control the crowds, if you like, okay. You know, do you go above the riots and things? Because you cannot use the mechanism of the state that you know, maintain peace and order within the state. You have to use the army. Okay, Northern Ireland, in effect, it was a non-international conflict, but it was never accepted as a non-international conflict. The British were sending the troops, all right, not only the police. So that creates a threshold, creates a problem. Then it is what kind of organization, and that, I mean, the threshold relates also to the intensity. What kind of organization a group needs to have, right? For Common Article 3, you have a minimum organization. If you go to Additional Protocol 2, which is for non-international conflicts, it's a higher level of organization. Okay, so the groups need to be organized almost, and also they need to control territory. Okay, but not all groups, armed groups, control territory. Okay, if you have this threshold, then it's difficult to satisfy, and then you don't have a non-international conflict.
Sir, but you told us that self-determination wars are international armed conflict, and at the same time when you tell us that the threshold for a non-international armed conflict is that you have to be organized as state and control territory, then isn't there a certain inherent dichotomy here? Because can't you classify, say, wars of self-determination also to be then non-international armed conflict?
Yes, I mean, it started when you had the wars of self-determination. The Western states wanted to say it's a non-international conflict. Then from the 60s onwards, you know, all the new states, they wanted to say it's an international conflict. Okay, so because of what is self-determination, you know, the importance and all the morality behind self-determination, it has been recognized as an international conflict. Okay, because of that. So the wars of self-determination, you have the group that claims that fights for self-determination. It's an international.
Can you give us an example?
In the 60s, you know, the wars in Africa, you know, all the groups that they were fighting wars of self-determination. I cannot.
Yeah, but then how? So exactly, how is it in international armed conflict?
Because you term them as a civil war, right?
No, the wars of self-determination, they're recognized as international armed conflicts.
No, sir. So, for instance, say if you take Sudan civil war,
Yes.
right? So now you say that a civil war is a non-international armed conflict, but at the same time, if you say that you're going to recognize it as an international armed conflict, then where are you drawing the difference?
Because it's a war of self-determination. You have a national liberation movement.
So is therefore today, if all of us decide that we want to create a new state,
Yes.
and we decide to go to war against India for that, because it's a war of self-determination, does it become an international armed conflict?
Yes. Yes.
So it's not about whether there's another state involved in the whole thing or not.
No, because it's a group fighting a war of self-determination. But the war of self-determination usually was when you had a colonial, you know, during the colonial era, right? So if you were fighting a war of self-determination, that was an international war. But the groups now that they fight, you know, they not fight, you know, in a civil war. They don't. In the post-colonial era, you don't have self-determination wars. It was the colonial finish, kaput. Okay. So now the wars, most of the wars are civil wars. Okay, unless you have kind of.
So what distinguishes the two? What distinguishes civil war from an international armed conflict if both can be? Is it if there are internal organized groups and the threshold is more than
There
five?
are, but they've been recognized as wars of self-determination because of fighting for self-determination. Okay. Because they were under colonial control, and they were fighting to have their own state, and they're recognized as such for moral, whatever reasons. The colonial powers didn't want to call them international wars; they want to call them non-international, right? But because of the morality, they've been recognized as international wars.
So then is it true that today no group fighting for self-determination, even within a large country, is sufficiently organized enough to count or causing sufficient violence in an organized fashion to count as an international armed conflict? Because I mean, even if you say take troops in Kashmir who are fighting in the name of self-determination or whatever, can you see that that's one example where we know they're not organized enough to meet this threshold? But is there no group today fighting on similar grounds of self-determination, but they don't have the kind of organization that's required?
Well, for the groups, I don't know, if there's any. The wars of self-determination finished in the 60s and the 70s, when you had it was based on colonial, Africa, Asia, etc. So you don't have any colonies anymore. Okay, so the wars were part of that, the 50s and the 60s, or early 70s. Okay, so it was in the colonial context. You fight the wars of determination in a colonial context. Now, is Kashmir colonized by India?
It doesn't fit the colonial lens.
Okay. So there can be a civil war in Kashmir, provided that the group, it's you have a group which is organized. There's intensity of fight. There's some intensity, so that can be a civil war. So if the Indian army, fights whatever group, I don't know if there's any group in Kashmir, which has certain organization and there's certain intensity in the exchange of fire, that's civil war. You're not happy with that. So what's the problem?
It's difficult to imagine that there are no groups today that are claiming self-determination and fighting for it.
Yeah, but self-determination, you have to see in international law for what it is recognized. So in international law, self-determination was recognized, and the laws of armed conflict for the context of colonialism. That's self-determination. Nowadays, you recognize what is called internal self-determination. You don't have the right to extend self-determination. So you have, unless perhaps you have some extreme cases. For example, Quebec, they want to have self-determination. That's internal self-determination. So Kashmir, for example, at this stage, they can claim, according to international law, internal self-determination. They can fight. I mean, no one can stop them fighting. Who's going to stop? If they win. They can have a state. But, they can start from civil war, right? And then it goes on, and that's the way it goes. So, in international law today, you have the right to self-determination, but that's not external self-determination, all right? It's internal self-determination. Does it make sense?
Yeah.
Sir, I wanted to ask, particularly when you were talking about 9/11 and the war of Afghanistan, it's an interesting. 9/11 is, I think, of interest also because it's an example where we have a state actor pitted against a non-state actor, which is in a different territory entirely. It's not in the territory of the original state actor. So, was this sort of transnational armed conflict, does it come under domestic, or does the war on terror come under domestic or
But
international?
9/11, the claim was that Al-Qaeda, well, Afghanistan was responsible because it failed. That was the attribution criteria, that Afghanistan provided the basis where Al-Qaeda operated, etc. So Afghanistan was responsible for the attacks in the 9/11 attacks. That's why the US action was against Afghanistan. So it was a kind of, state, it was a proxy, but the proxy was, the acts of the proxy were attributed to the state because it harbored, tolerated, etc., Al-Qaeda. And that's an international armed conflict. But the question is, the question I asked is, did it start in 9/11 or in October when the US took action against Afghanistan? We tend to treat it from October, whatever, 2001. So that's why what happened to the 9/11 people, right, isn't a black hole, because otherwise humanitarian law would have applied. They would have been prisoners of war. Okay, so questions can be raised. Now, what is the war now in Afghanistan? You have international troops. It's a non-international conflict. Of course, the Americans claim that because you have, the war on terror, etc., but there's actions by the US in Pakistan, etc. So it's a non-international conflict that spillovers to neighboring states. Okay, so you have people, Talibans, etc., that from Afghanistan they go to Afghanistan, from Afghanistan they go to Pakistan. So you have a spillover of a non-international conflict. So we can take action in Pakistan as well. And that was also the decision, the Hamdan decision by the US Supreme Court. But for non-international conflicts, the threshold depends on whether you apply Additional Protocol 2, where the non-state action is to control territory, or you apply Common Article 3, where you have minimum organization and minimum kind of intensity of the armed conflict. Okay, so all these things, concerning the definition of armed conflict, and when does an armed conflict begin? Also, when does it end, an armed conflict, right? If you have a ceasefire, for example, does it end the armed conflict? All these things cause a lot of difficulties in the application of the law. Now, if we go then to the definition of the crimes.
Before we move on, you said that till the 60s, when there had been self-determination wars against colonial powers, those were categorized as international armed conflicts. But if something happens now against the country's legally established government, it's not international armed conflict. Is it because during those days there was a foreign power, the colonial power involved in the war of self-determination, that it used to be termed as international armed conflict, whereas today mostly the self-determination wars are against the local government? And
well,
there's no foreign power, unless obviously there's a foreign power involved supporting the rebels. That makes it international.
Yeah, I mean the main reason is what I explained, is the morality of the wars of self-determination and the colonialism, being a bad thing, and the fact that it's perhaps the opposite as well, because if you recognize an international conflict, those self-determination groups are treated as other states. Okay, so there were those groups, the self-determination groups, they were governments in waiting, right? And international conflict, the law of international conflict has more protections than the law of the non-international conflict. The law of non-international conflict is very limited, and the state can use criminal law, they can use whatever it is to suppress the conflict or the activities of the non-state actor. So it was the morality, the fact that they were treating them as governments in waiting, as they're going to form the new government. Okay. But nowadays, self-determination has a completely different meaning in the world. I don't know if it's a completely different issue, but I mean, do you think that self-determination, what do you think about this internal and external aspects of self-determination nowadays? So, I mean, do you think that people within whatever state, say India, they have the right to external self-determination, or internal self-determination like autonomy, self-rule, etc.?
So in ICCPR, the right to self-determination is regarded as one of the cardinal principles, but India has not ratified the right to, the part which talks about the right to self-determination. So in India, the right to, because of the Kashmir issue and a lot of other issues, is not considered to be a valid right.
But if we take the view that nowadays the model of self-determination is the post-colonial is about internal self-determination and not external self-determination, that would mean that Kashmir can have autonomy or more autonomy or something, and that's what is self-determination. So it's not to have another state. And the idea again is that, you know, if you split states to smaller units, you create more problems than you solve. But anyway. Now, if we go to Article 8 and the definition of war crimes, okay. It's interesting that Article 8 divides the crimes to those committed in an international conflict and those committed in a non-international conflict. And again, within each basket, so you have the international war crimes, so the non-international war crimes. Of course, there are a lot of similarities, and in international jurisprudence, there is the view that there is a common law for armed conflict, irrespective of whether it's an international or national. Of course, that creates a lot of problems as far as armed groups are concerned, because they may not be able to fulfill some of the obligations. But Article 8 divides crimes to international conflict and non-international. And then, within each basket, kind of divides crimes. For example, in 8A, the first part is grave breaches of the Geneva Conventions, but then 8B is other serious violations of the laws and customs applicable in international conflict within the established framework of international law, namely any of the following acts, okay, and then enumerates acts. And then if you go to non-international armed conflicts, you have 8.2e, which says in the case of an armed conflict not of an international character, serious violations of Article 3, common to the four Geneva Conventions, then it enumerates, you know, which specific acts. And then you go to E, it talks about other serious violations of the laws and customs applicable to armed conflicts, not of an international character. Now, what does this mean? It means that the first part, for example, Article 2A, when it talks about grave breaches of the Geneva Convention, it means that these are established war crimes. So there's no question about whether these are crimes. For example, willful killing, torture or inhumane treatment. These are established crimes. If you do them during an international conflict, you have criminal responsibility. What is interesting about torture? Torture can be a crime against humanity. For a crime against humanity, you don't need a purpose. You don't torture someone in order to get information, to intimidate, etc. And you don't need an official person to commit the torture. Okay. Whereas for war crimes, you need both, an official plus a purpose. Then extensive destruction, etc. Prisoners of war. Now, if you go to taking hostages, unlawful deportation, etc. If you go to B, it talks about other serious violations of the laws and customs applicable to international conflict. And then it talks about certain acts, but it says within the established framework of international law, namely any of the following acts. What does it mean? It means that in order for the court to prosecute on the basis of the particular acts under A to B, it needs to establish whether this particular act is criminalized in international law. Okay, so it is not that the court can exercise none of these acts ipso facto and immediately constitute war crimes. It has to be proven that they are war crimes. Okay. Now, if we talk about nuclear weapons, for example, is the use of nuclear weapons prohibited in international law? No. Can you use then nuclear weapons in an armed conflict?
Depends on the situation according to the International Court of Justice views in the judgment on this use of nuclear weapons in war. They hadn't said, the report hadn't stated that it's completely barred. Unfortunately, did not even lay down any exhaustive list when it can be used, but then it definitely left the door ajar as far as using nuclear weapons are concerned. So that definitely means that it can be used in certain circumstances.
Okay, so for example, if you go to 2B10, okay, what is the X10? Can someone read it out? Oh, no, 10, sorry. It is, let me see. It's 20.
Employing weapons, projectiles, and material and methods of warfare which are of a nature to cause superfluous injury or unnecessary suffering, or which are inherently indiscriminate in violation of the international law of armed conflict, provided that such weapons, projectiles, and material and methods of warfare are the subject of a comprehensive prohibition and are included in an annex to the statute by an amendment in accordance with relevant provisions set forth in Articles 121 and 123.
Good. So if you use nuclear weapons, do you violate, is it a war crime according to number 20? Or cluster bombs? Do nuclear weapons cause superfluous injury? Are they indiscriminate? They are. Well, it depends if you use strategic or tactical nuclear weapons. Superfluous injury, yes. Unnecessary suffering, yes. Are they prohibited? No. The same with cluster bombs. States, a lot of states, they have reservations to the additional protocol 1, etc., which excludes the use of nuclear weapons. And there is no agreement in international law as to whether you can use nuclear weapons. Okay, so that goes back to what I said about Article A to B. For the specific time, so you can, if someone, a friend that they have reservation, use nuclear weapons, you cannot prosecute that person under A to B20 because according to French law, that's not unlawful, right? And there's no agreement, international agreement as to the use of nuclear weapons. That's why the court needs to satisfy itself that the specific act or the specific method, etc., is criminalized under international law. Okay, so the first part, it has crimes that are established, so there's no question about that. The second part, it has crimes that the court needs to prove, as it said, accepted in international law. Now, some other innovations of crimes is under 8B3. That's the first time that has been included. Does that someone want to read it out?
Intentionally directing attacks against personnel, installations, materials, units, or vehicles involved in a humanitarian assistance or peacekeeping mission in accordance with the Charter of the United Nations, as long as they are entitled to the protection given to civilians or civilian objects under the international law of armed conflict.
Good. So that's the first time that attacks on peacekeeping has been included as an international crime. Okay. Perhaps you know that, okay, peacekeepers may commit crimes, but also crimes may be committed against peacekeepers. Now, the problem with this provision is that an attack on a peacekeeper can be a war crime only if the peacekeeper is entitled to the protection given to civilians. So, if a peacekeeper is involved in an armed conflict, then can be a target, it's a legitimate target. But according to the UN law, if the peacekeeper, so for a day, the peacekeeper fights, can be a legitimate target, there's no war crime if you kill a peacekeeper. Next day, the peacekeeper does not fight, is a civilian. So if you attack a peacekeeper, that's a war crime. Okay, that causes a lot of problems, and because you don't expect the other party to know, if the peacekeeper is now combatant or is a civilian, right? So I think the better way is that peacekeeping operations, which have a mandate to use force, right? For this peacekeeping operation, for the duration of the peacekeeping operation, humanitarian law would apply, and therefore attacks on the peacekeeper would not be a war crime. Otherwise, it disadvantages the other parties because they may find themselves as committing a war crime, but they didn't know that the peacekeeper today, he's off and doesn't work. So it's better if you say that the peacekeeping operation is involved in hostilities, humanitarian law applies, so they can be combatants, they can legitimately target and kill someone, but they can also be legitimate targets without the other party committing a war crime. And another interesting provision is 26. Who wants to read that?
conscripting or enlisting children under the age of 15 years into the National Armed Forces or using them to participate actively in hostilities.
Okay, so it's about, perhaps you know, child soldiers. Okay, so conscripting or enlisting children under the age of 15 years. All right. Conscripting means what? And what does enlisting means?
Conscripting is forced, compulsory, while enlisting would be voluntary.
Yes. Voluntary in quotation marks. Okay. Because, you know, it's not always that they want it. But it's money, it's, they promise them they're going to get married or get, you know, whatever, booking. So, but the age is 15 years old, right? National Armed Forces. Now, National Armed Forces can be a more general, wider view of forces, and using them to participate actively in hostilities. So, actively means not only directly participating in hostilities, but any kind of activity that will endanger the life of the child. So those that they conscript or enlist, they can be criminally responsible, provided that they knew the age of the child, or they should have known the age of the child. Okay, they should have inquired to find out the age of the child. But this is up to the age of 15 years old. You have the additional protocol to the Convention on the Rights of the Child, which sets the limit to 18 years old, right? And the age for the criminal prosecution for the ICC is 18 years old. Okay, so that creates a gap, if you like, of 2 years, right? So if you conscript a child, well, however you call it, but that is 17 years old, you don't commit a crime, right? Because it's up to the age of 15. But the Convention on the Rights of the Child says 18 years old. So the question here is about the interpretation of this provision and whether the ICC, the court, will use, say, customary international law. We talk about the sources of international law, so that is an additional aid in the interpretation of the ICC provisions. So whether they're going to use custom international law, provided that there's any custom international law that says that the age of maturity is 18 years old. So anything below 18 is a child, so it is prohibited. Of course, certain states, like the UK, they have 50 years old for the army. Okay, but there are other states that have different laws. So the question is whether there is any kind of custom international law that puts the age of maturity to 18 and not 15. In that case, the gap that exists between the Convention on the Rights of the Child and the ICC statute would close. Okay, and also there would be harmony between criminalization and age of maturity and this article about conscripting children. Okay, I think we can have kind of 10 minutes break and then we'll continue with the crime of aggression. So we can move on to crime of aggression. And I think I have discussed with some people about the whole thing about self-determination. So perhaps I had more kind of, standard to the Western view. Extent self-determination was colonialism finished. Now you have internal self-determination. And also I have to say that self-determination is not only to have your own state. Self-determination is something more than that. It's about democracy, it's about human rights. So what's the point of having your own state where your state is going to attack you, imprison you, etc. So in my view, self-determination is something wider. It's about the people to determine themselves, but not only in relation to having a state, but also in relation to their context, their lives, etc. Now, going to aggression, or crime of aggression. You know that according to Article 5, there is the ICC has jurisdiction over the crime of aggression, but they can exercise jurisdiction after the crime of aggression has been defined and, of course, ratified, etc. In the Nuremberg Tribunal, it wasn't kind of aggression, was the crimes against peace, which to some extent is the equivalent to what we now know as a crime of aggression. And of course, that was one of the big issues as to whether it's retrospective law, meaning whether when you didn't have the prohibition of war, or you had a prohibition of war that wasn't kind of widespread, or wasn't customary international law by 1940s, and of course you didn't have criminalization of going to war. So the question of how you can try someone for waging a war. But as I said, as we said, it has been sorted out by the tribunal in this kind of very normative approach to the principle of legality. Aggression, there was tried to be a definition of aggression by the International Law Commission, or the crime of aggression by the International Law Commission. They didn't succeed. So the two, if you like, important events is the General Assembly Resolution of 1974, which defines aggression. Okay, there's the 1974 General Assembly Resolution that defines aggression. And then you have the Kampala Conference that defined the crime of aggression for the ICC. Okay. Now, the definition of the crime of aggression is based on the General Assembly Resolution. Okay. The problem with that, and as you may understand, I'm not one of the kind of very sympathetic with the definition of the crime of aggression, and I think it's a lot of nonsense, political nonsense, but it's there. The issue is that the General Assembly Resolution is a political, it's not a legal definition. The General Assembly Resolution was in order to assist the Security Council in determining aggression or acts of aggression. So the Security Council, under Article 39 of the UN Charter, has the competence to determine whether there is a threat to the peace, a breach of the peace, or an act of aggression. Okay. The General Assembly Resolution on the definition of aggression was passed in order to help the Security Council to determine whether it's an act of aggression. Right. Now, the determination by the Security Council is a political determination. Right. It's not a legal determination of what is aggression. Okay. Has the Security Council ever used the General Assembly Resolution? Never. Has the Security Council have determined that there is an act of aggression in its life? For example, when Iraq invaded Kuwait, that was aggression, if you like. Did the Security Council say it was aggression? No. Okay. So the Security Council said only in 2 or 3 cases that there was an act of aggression, and of course there is politically charged. One was concerning Israel, for obvious reasons, South Africa, and I think that in 50, 60 years, the Security Council only mentioned that the state has committed an act of aggression in 2 or 3 times, right? The other thing about the General Assembly resolution is that it includes, as the definition of the crime of aggression, certain examples of acts of aggression, right? But all these examples, they have been qualified that the Security Council will determine in the context of the situation. So they are not the examples, for example, bombing, what it says, the invasion of a state, which is one of the acts of aggression, right? It's qualified that the Security Council will determine whether it's aggression within a context. You have the definition of the crime of aggression, and this has been taken out, all the qualifications. So all these acts are represented here as being the law, which is not the law. And the General Assembly resolution, when they passed the resolution, didn't say that, you know, this is the law. It said that these are examples, and the Security Council may decide differently, right? And the final thing is that the General Assembly resolution says in Article 5 of the resolution that a war of aggression leads to criminal responsibility, acts of aggression lead to responsibility. Okay, so what it said is that a war of aggression gives rise to criminal responsibility, acts of aggression give rise to state responsibility. The definition of the crime of aggression, the Kampala definition, says that acts of aggression lead to criminal responsibility. Okay. So, this kind of introduction, which is negative, so I kind of preempted, you know, what is the problems with the definition. So if we go to the definition of the crime of aggression, which, as I said, is taken by the General Assembly resolution, which is political, you have Article 1 that defines the crime of aggression. Okay, so it says for the purpose of this statute, the ICC, crime of aggression means the planning, preparation, initiation, or execution. Okay, that is taken from the Nuremberg tribunals, the crime against peace, by a person in a position effectively to exercise control over or to direct the political or military action of a state, of an act of aggression, which by its character, gravity, scale, constitute a manifest violation of the Charter of the United Nations. Now, if you read something with too many words, it means that, you know, it's nonsense, and that, you know, it's very difficult to kind of find the law, you know, what's the crime. And then in paragraph 2, explains what is an act of aggression, and then it gives examples. So it says, for the purposes of paragraph 1, act of aggression means the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations. And then it gives acts. Okay. Now, if we take the first part, there are 2 issues in the first part, well, more than 2 issues. But first of all, aggression is a leadership crime. Okay. It is only those persons in a position effectively to exercise control over or to direct a political or military action. Okay. So it's not the soldier, okay, it's the leadership. So it's a leadership crime. Okay. Now, in democratic societies, of course, the decisions to go to war are made by the government. Of course, the question is whether it's the government or whether it's the cabinet who decides. And it's not necessarily the head of the army. Of course, they can participate, etc. So it depends on the decision-making power. Okay. So it is, if you are Saddam Hussein, for example, or dictator, then, and you wear your uniforms, etc. So, you know, the kind of military and the political leadership is, you know, kind of accumulated to one person, then, you know, there's no problem. But in democratic societies, is it the parliament may decide, but who actually has the power to control? It's not the parliament. They can make a decision, but it's mainly the government. But then who from the government is the other question. Now, a kind of interesting point here is that nowadays you have problems with non-state actors, ISIS, right? If I read all the acts that they constitute aggression, they can do it then, right? Or they can do more than that, right? So it doesn't contain anything about non-state actors. It's everything about states. So non-state actors can do whatever they like, but they commit no crime. Okay? But non-state actors like ISIS, they have an organization, they have a leadership, right? They can make decisions. Why not? Okay. Of course, they cannot be parties to the ICC, etc. That's a different question. But the definition of the crime of aggression excludes non-state actors. But nowadays, our problem is non-state actors. States are, you know, cause problems, but non-state actors cause more problems. Okay, so the first is the leadership thing. Then it says that the act of aggression should, by its character, gravity, and scale, constitute a manifest violation of the Charter of the United Nations. Right? So its character. What does it mean, character? Gravity, scale. Scale, okay. Perhaps, you know, the widespread, we were talking yesterday, it's, you know, the scale of the operation. 2003, Iraq, there was the bombing campaign, so there was a scale. Gravity in what sense? Gravity as far as the violation of the law is concerned. So it's a grave violation of the law. So for example, if India sends one soldier and invades kind of Pakistan, is it grave enough compared to if India sends 100,000 soldiers to Pakistan? Okay. Is it grave because one plane destroys whatever military installations with one bomb? Is it grave because India or Pakistan kind of removes the Indian leadership, removing, assassinating, killing, or whatever it is? Is it grave that all the, perhaps you don't like them, you are happy, but you know, say all the prime minister, president, everything, you know, is it grave, this thing? So what is grave? character. What if I use cyber means that, you know, they are very smooth, and I destroy, I kind of, well, you have a power plant, you bomb it, okay, it's a big thing, okay, it's fire, you destroy the thing, fire, so I use cyber means, I completely kind of use some power to paralyze the system so it doesn't work, right? Is it better? Right? Okay, I didn't destroy it. There's no fire, there's nothing, but you know, the system doesn't work. There's no produced power again, but that's in a you know, kind of better way. So, so that does it make it better, worse?
So I believe it's the kinetic damage test which says that if you could have accomplished the same result using the conventional means of attack, then it still counts as an act of aggression as well. Because you could have, for instance, crippled the power infrastructure of a country by detonating a bomb. So, because the end result was the same and could have been otherwise accomplished, it still amounts to, your action still amounts.
Okay, yes, it may, but is it because of, you know, the way I do it instead of, you know, bombing? And because if you bomb it and then you have the problem, then of course all the consequences, because you don't have the power plant. But I do it through cyber means, so you know, I don't have, it's not destroyed, it's there. Of course you have the same consequences, but does it make it kind of smoother? Like it's killing someone with a cotton thing, you know, that's, so what I want to raise is, you know, there's a bit of, a lot of questions here. So all these acts, they need to be also manifest, that violation of the charter. Manifest to whom? Okay. So manifest means must be evident, but to whom that it should be violation of the charter? To all the states of the world? Right? To some? To the UN? To the Security Council? To whom? Okay. And then it goes on to say that act of aggression means the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner consistent with the Charter of the United Nations. This is Article 2.4 of the UN Charter, with the additional sovereignty. Sovereignty is not in Article 2.4. Sovereignty is a very kind of all-inclusive concept. Now, when in 1971 India invaded what is East Pakistan, what is now Bangladesh, right? Is it an act of aggression? If you take this definition. Okay. So is it an act against the sovereignty, territorial integrity, or political, not an act of aggression, crime of aggression, so for the leadership? Was it Indira Gandhi, Prime Minister? Indira. So did she commit the crime of aggression? Because the act of invading, and then if you go to the examples, it says the invasion or attack by the armed forces of a state of the territory of another state. Okay. The bombardment of another state. So when Indira Gandhi ordered, you know, the victorious Indian troops to enter Bangladesh in 71, was it an act against the sovereignty, territorial integrity, or political independence of Pakistan, or in another manner consistent with the Charter of the United Nations, which was, because of its character, gravity, and scale, a manifest violation of the United Nations Charter? And the camera is here, so they can listen to what you say. What do you think?
Yes, it was.
Why?
Because it did satisfy all the characteristics of an active aggression as we just discussed, and it was indeed an armed force of India was indeed going against the sovereignty. I mean, it was trying to take the sovereignty, territorial integrity or political independence of East Pakistan.
But was it of such a character? I mean, they went there to save the Awami League, you know, people that have been killed by the Pakistani regime. That was for good reason. That was for good reason. They went there to save people that they were massacred by the Pakistanis.
But as the definition I see it, it does not have any exception for a good or a bad reason. So I'm not quite sure whether that would qualify as an exception to this definition.
Okay.
Are there any customary differences to this?
Sorry?
Are there any customary differences?
In what sense?
Say customary international defenses to the crime of aggression? Or when is the crime of aggression justified?
Okay, those are questions. Was it for a good reason? Was it for humanitarian? Is it against the UN Charter to invade a country to save people? Was the character good? Did everyone see the intervention as being a manifest violation of the UN Charter? Was India condemned? Not by only Pakistan, but you know, from other states, or did they kind of applaud it, India? Okay, so what I want to say is that India was not overwhelmingly condemned. There were people that said that was humanitarian intervention and that was a good thing. Okay. So some may say that it was because it was humanitarian intervention, so the character of the action means that, you know, it's not against the UN Charter. So you may say that it was not manifestly a violation of the Charter, and the character, etc., does not make it so bad. So it's very difficult, you know, to say whether a crime of aggression has been committed. Iraq, 2003, was it a crime of aggression?
Yes, and that is probably the reason why US wasn't very enthusiastic about the ICC.
Okay.
Crime of aggression.
But was it a manifest violation of the UN Charter? Did they say that was legal? Or if it's the British, the Americans, and some other states, did they say that was legal?
Well, the reason that they had given was that there was the presence of weapons of mass destruction, because it wasn't as if there was a humanitarian crisis going on in Iraq. So the reason for the intervention was never proved technically. So
yes, later. But when you make the decision, the question here is that everything depends on the time you make the decision. It's not later. So when you make the decision, it's whether, you know, you satisfy these things. I mean, later things may happen, but it's at the time that you make the decision. Okay. Sorry.
Certain their attacks, a lot of the bombing was on the sewage lines and water lines. So regardless of what their justification was, their actions didn't correspond to looking at military sites in the first place. So
yeah, but the first thing, okay, later they can have done other stuff, violations of the law, but when they went to Iraq in 2003, the question is whether this action was a crime according to the definition of the crime of aggression. And the main question here is whether it was manifestly violation of the Charter. They said that they had Security Council authorization, the previous one. Then it raises questions about preemptive or preventative defense. So, you know, whether it's legal or illegal, lawful or unlawful, preemptive or preventive self-defense, there are different views. Okay, so what I want to say is that since international law does not have a clear rules about, say, self-defense, preemptive self-defense, preventive self-defense, about humanitarian intervention, etc., and all these issues are debated, there can never be a manifest violation of the UN Charter. Right. Unless you have Iraq going to Kuwait in 1991. That was a crime of aggression, and there wasn't anyone, apart from Iraq, that said that was legal. That was a kind of invasion of another state. So at the end of the day, the view is that it's very difficult to prove it. Okay, so even if the crime of aggression is there, I don't think a lot of people will lose their sleep. Okay, neither Tony Blair or whoever, because it's very difficult to prove it. If you go to the acts of aggression, for example, under F, it says an act of aggression is the action of a state in allowing its territory, which has placed at the disposal of another state, to be used by that other state for perpetrating an act of aggression against a third state. Okay, so if India allows Nepal to use Indian territory to attack Pakistan, then India commits an act of aggression, fine. But if India allows Group X to use its territory to attack Pakistan, that's not a crime of aggression. Right? So that's another big problem with the definition of aggression. Okay. Concerning the issues of jurisdiction, so in order for the crime of aggression to be, for the ICC to exercise jurisdiction for the crime of aggression, you need 30 states to ratify the amendment, right? So you have a lot of states. I mean, Palestine has, but Palestine is a different issue, so you need real states to ratify it. And then from next year, there needs to be a 2/3 majority decision by, that's Article 15 piece of the amendment, by the Assembly of States to accept the amendment. Okay, so first 30 states to ratify, and a 2/3 majority by the Assembly of States of the ICC is like the legislative body of the ICC, to accept the amendment. And if that happens, so that will be next year, all right? If that happens, then it will be a crime under the jurisdiction of the court, and the court will have, can exercise jurisdiction. Now, what about concerning non-state parties? As it says, there can be, it's paragraph, paragraph 5 of Article 15b, the amendment. The ICC cannot exercise jurisdiction over the nationals at all. So the ICC can exercise jurisdiction over nationals of non-state parties if they commit a crime on the territory of a state party. But as far as aggression is concerned, it cannot exercise jurisdiction, even if they commit a crime on the territory of a state party. Okay, so the US is happy. What about the other members, the parties to the ICC, that they haven't ratified it? Okay, but then, you know, there are parties, there's jurisdiction for the crime of aggression, would the ICC exercise jurisdiction with regard to those states? Right. Now, these states can launch a declaration whether they accept the jurisdiction of the court. But also states that ratified can launch a declaration whether they accept the jurisdiction of the court. Okay. So at the end of the day, and for the ICC to exercise jurisdiction, it means that if it is, say, between states, both states, they need to have accepted the jurisdiction of the court, right? Say the state of nationality and the state of territoriality, right? So at the end of the day, the crime of aggression may be there as a crime, but the ICC may not be able to exercise jurisdiction, or may have very limited jurisdiction. So the situation then is that for the other three crimes, the ICC can exercise jurisdiction. So if you become a party to the ICC, then there's automatic jurisdiction by the ICC. When it comes to the crime of aggression, there's no automatic jurisdiction, even if you are a state party to the ICC. Okay. Because you can lodge a declaration not accepting the jurisdiction of the ICC. So that's the situation with the crime of aggression, and personally I think it was a big mistake that you had introduced, you know, a crime of aggression, in particular the way you have defined the crime of aggression. Of course, you can understand the reasons why you have it, and which states have been promoting the crime of aggression, but all the states that, or most of the states that they were promoting the crime of aggression, they now want to leave the ICC. And I'm talking about the African states, and have their own kind of, their own court, etc. So that's my final view about the crime of aggression, how it's going to work, but I believe it's, even if it is there, I very much doubt that there would be any kind of prosecution, but also for the ICC it would be very difficult to exercise prosecution because it's a very, very political issue. Another issue is the relation between the ICC and the Security Council, because I said that the Security Council has competence to decide whether it's an act of aggression, that's Article 39. Okay? It's of course a political decision by the Security Council. So you have Article 6 of the Article 15 bis, the amendment, that says, where the prosecutor concludes that there is a reasonable basis to proceed with an investigation in respect of the crime of aggression, he or she shall first ascertain whether the Security Council has made a determination of an act of aggression committed by the state concerned. The prosecutor shall notify the Secretary General of the United Nations of the situation before the court, including any relevant information. When the Security Council has made such a determination, the prosecutor may proceed with the investigation in respect of the crime of aggression. Okay. So if the prosecutor thinks that there is a crime of aggression, they will notify the Security Council, try to see whether the Security Council has made a determination. Well, in 60 years, it made 3 determinations. I don't think there will be any more determinations in the future, but you never know. Where no such determination is made within 6 months after the date of notification, the prosecutor may proceed with the investigation in respect of a crime of aggression, provided that the pre-trial chamber has authorized the commencement of the investigation in respect of the crime of aggression in accordance with the procedures, etc. Okay. Now, if there is the Security Council, there's no action by the Security Council, etc., then the prosecutor can proceed, provided that the pre-trial chamber authorizes. That's a kind of guarantee that you don't have a kind of maverick prosecutor that just issues indictments against everyone. So you have the pre-trial chamber to authorize, the commencement of investigation by the prosecutor. Now, can the Security Council do something? Can the Security Council stop the prosecutor? So it says that the prosecutor can proceed if the pre-trial chamber authorizes. If you remember, when was that? One of the second or third. The Security Council can defer, ask for deferral, okay, under Article 16 of the ICC statute. So if the prosecutor proceeds, the Security Council can pass a resolution under Chapter 7 requesting the prosecutor to defer any investigation, right, for a period of 1 month, of 1 year. And that can be repeated, okay? As we said, the prosecutor is not bound by the Security Council resolution, and the ICC is not bound, right? Of course, the prosecutor can proceed, but, politically, I don't know if it is the best thing for the prosecutor, right? However, the Security Council can order states not to cooperate with the prosecutor, right? And all the states are bound by the Security Council resolution, if it's under Chapter 7. So, if the prosecutor was to investigate and go, I don't know, to come here to India to investigate whether there's the evidence, etc., whether an act of aggression has been committed, India, if there's a Security Council resolution that says no state should cooperate with the prosecutor, India is bound, right, not to cooperate with the prosecutor, right? You can say, no, you don't come to us. Because it is a Security Council resolution, and if there is a conflict between that obligation, India's obligation towards the Security Council, and India's obligation towards, it's not a party to the ICC, but say that it was a party to the ICC, to cooperate with the ICC, under Article 103 of the UN Charter, its obligation under the Security Council resolution will prevail over its ICC obligation, right? So India will not commit any violation of the ICC statute. Okay, so that would be the end of the story. Okay, so that's as far as aggression is concerned. So do you have any questions, or you want to discuss something?
With regard to deferral, the language that has been used over there is no investigation or prosecution may be commenced or proceeded with. Wherever there is may, there can be the prosecutor may go ahead with it. So
yeah.
effectively, the deferral is not compulsory binding.
Well, the deferral is not, by the security council, it does not bind the ICC, it does not bind the prosecutor. That's why it says may. The prosecutor may proceed or may not. I mean, they can see the Security Council resolution and they may say, okay, it's better not to proceed now for many other reasons, right? But you may proceed, right? But the states, if the Security Council says to the states you don't cooperate, are bound by the obligation, so they shouldn't cooperate.
So the may in this case basically functions like a shall. You shall not cooperate.
Well, the shall is kind of more determined.
Yes, it seems to be.
So the prosecutor, yes, may or may not proceed. So nothing stops him because of the deferral, because it's not bound by the deferral. Because if it was bound, it would say that should not or shall not proceed. Okay, so it's not bound, may not. Okay, so then tomorrow at 11, isn't it? Or is wrong?
11 a.m.
11, good, okay. And go through these scenarios.